So, number one topic today, breaches of contract. A lot of people default on closing transactions, right? You help with a lot of litigation cases.
Yes.
Can you tell us the situation in Toronto today and
Yeah.
how?
Yeah, it's rather unprecedented right now. We're seeing a huge uptick in breach of contract default on behalf of the buyers. You know, for various different reasons, but most of the time they just can't get the financing together at the last minute, and that's because of the rising interest rates and the values of the properties are coming down. The appraised values are always coming down. Conventionally, it was the appraisal would be what the value of the home was when you purchased it, but now by the time you purchase it and you close it, 2 or 3 months later, the appraised value comes down, $100 or $200,000 on a $2 million property. So you have to
Big
come
trouble.
up you have to come up with $200,000 at the end of the day to cover that shortfall, and a lot of people can't do that. They're already over leveraged, and the banks are increasing rates, so they're becoming less and less affordable and less qualified. So that's a huge problem these days. It's always a problem. Every 4 or 5 years when we hit a recession, 2017-18 there was a big problem.
Yeah. How does it compare to that?
Uh,
Is it
Not similar. This is way worse, for sure,
Than
than
2017?
2017-18. I wasn't practicing in real estate litigation exclusively then, but from what I hear from my colleagues, uh, it was bad then, but this is like the perfect storm, so to say, and it's prolonged. Like we're talking about over a year and a half now, pretty much or about a year at least of defaults. Like and they're still coming in. So obviously, June, July was big. Was early last summer, spring, was really really bad for a lot of people. The property values dropped like 15% overnight almost, and a lot of people got caught. A lot of people bought before they sold. So trying to the shortfall is now double. Like you think you're going to get $1 million for your home and you're trying to sell it, but now you're actually only getting 800,000. But now
You're short.
and you're short now because you bought a house already, and that property you need to come up with 200,000. So now you have to come up with $400,000, and a lot of people are in really dire straits as a result of that. So my practice really has grown considerably over the last year to the point where I only represent sellers at this point on real estate litigation files, just because there's so many of them.
How many you have, if you can say?
Probably about 60 files, active litigation files,
Wow.
all with the same set of facts, pretty much. So
So correct me if I'm wrong. I always tell my clients, no matter what, close the deal.
yeah,
I don't know, beg for money,
Yeah,
take a
for
second
sure.
mortgage, do something, because at the end of the day, you will pay much more than after you lose in
Yeah.
court pretty much, and you will always lose.
You will always lose. Yeah, like the case law is very very clear. If you breach a deal, from the beginning of time, whether it's real estate or any sort of contract, you're going to end up paying damages for it, and these damages are extensive. The difference between your purchase price and the resale price in this market.
And
Yeah.
a lot of people think, oh, I'm just gonna lose the deposit,
Right.
and that's it, which we know
Yeah.
is wrong.
The deposit, is at one point it's you need to put a deposit for sure to have to continue on with the deal. If you don't put a deposit down, it's still a live deal, but you're in breach. So that's one issue that we're seeing. A lot of people are bailing on these deals, and they're just not putting their deposits down right out of the gate. Well, that's a big breach. That's a breach of an agreement right there. And so we have probably about 10 or 15 of those files on our desk.
So they decided
Yeah.
not to.
They just
pursue.
decided not to go ahead with it. It was very popular when the market was hot. People would go out and they would, they would put offers on 10 different homes over the weekend, and then by the time the weekend, the dust settles, they get 2 or 3 secured deals,
Yes.
right? So then they just end up bailing on 2 of the deals. They buy our house, but the problem is that that you've taken those two other deals off the market, and then those sellers are trying to resell, and they sell at a loss, right? So then, that loss is, they go after that buyer for
I
default.
mean, in a hot market, they resell it and was no problem.
Exactly.
But right
Yeah.
now,
Yeah. Hot market's generally not that big of a problem, right?
Yes.
However, there is a case that we worked on, in the height of the market last year, and started 2 years ago, and it was the height of the market. The buyer overpaid for it, so then at the end of the day, when they resold it for $140,000 less at the top of the market. So it's still a very a serious thing to do, to breach on failing to deliver.
But having
deposit.
said that, it is breach of contract. You have to
Fundamental
always
breach
deliver.
from the beginning of
Yes.
time.
A lot of people think, I don't deliver deposit, there is nothing happen. But
Very
you have
common
a seal,
misconception.
agreement of purchase and sale, and the deposit is just a part of the agreement which have to be delivered, right?
Yeah, it's the first step in the agreement that you've already signed.
Yes.
Even if it's a conditional agreement, you still have to put the deposit in.
Yes.
If you don't put the deposit, you're in breach, and the other side can terminate the deal and sue you. So it's but a common misconception. A lot of lawyers, a lot of realtors, they all they just have the idea that if you don't put a deposit, there's no deal. Like if
Yes.
you're on Kijiji or something like that, buying a car, But at the end of the day, for real estate deals, once you sign on that dotted line, you're in breach if you don't fulfill the deposit within 24 hours. So
Yes, I had few clients which had the same, understanding that, okay, I'm not putting deposit.
Yeah.
No, you're completely wrong.
Yep.
And, you could be sued for it, and so.
still happens. I had probably 4 or 5 people last week call me about the same thing.
Great.
Still happens. It's very common.
How is that? Like how
Yeah.
can lawyer not be educated about it? Like
Lawyers are coming
like you
around
said,
to it. Yeah.
Fundamental breach of contract.
Look, the lawyers are, only a select few that I've come across have made that argument, and then as soon as I bring their attention to, the case law, then they change their mind pretty quickly. But a lot of realtors, a lot of young realtors, they just don't know. Either it's not taught, at school, or I'm not sure what but generally it might be their first deal, and it happens quite often. And just the volume of transactions, it's just bound to happen here or there. Like some people have, I had a client that, had a medical emergency and couldn't deliver the deposit, right? So there's other reasons why, you fail to deliver the deposit other than, your own choice. But, back to, where we are today in the market, and your advice to your clients is sound, that you should close these deals, whatever it takes. That's very true, because if you don't close, the seller is going to end up in my office, and we're going to sue you, and there's hundreds of thousands of dollars on the line.
Not only the deposit, but
the deposit, and then you'll lose the deposit if you paid it, and then you also the difference between the two sale prices. Generally these days, I've had one client earlier this year at $900,000 was the difference between the two sale prices.
wow, that's a lot.
A lot of money. But generally we're looking at between $200,000 and $400,000 in damages. And if
Legal fees.
legal fees on top of that as well. So, but and then if you own a property, if you're a defendant and you own a property, then that judgment is going to get registered on title to your property through what's called a writ of execution. It's a lien essentially on title, so you can't even sell your property, you can't mortgage your property unless you pay out that judgment. So as a purchaser that is considering a default that owns a property, they should be taking whatever like a beg, borrow, and steal to get
That's what I tell them, yes.
to close that deal, or go to a lawyer that can negotiate some sort of a resolution for you, and do that quickly, because you have to close these deals. The only thing that's good that's going right now for buyers in that situation is that sellers are usually desperate as well. So sellers are they're giving extensions. They're sometimes they're even giving reductions, abatements in the purchase price. So people are cooperating for the most part, just because the market is is still kind of declining in certain areas. So sellers want to close these deals as well. So there is a bit of cooperation going on for sure, but there's the odd party that just doesn't really care about the contract, and as a buyer, they just screw off, and we'll come knocking at their door later on. So
Also, having a good litigation lawyer helps, right?
yeah,
They
for
know
sure.
what they're doing and protect their clients.
Yeah.
If the buyer breaches the contract, what options and tools does the seller have to collect the damages
Right.
awarded if the seller refuses to pay?
Yeah. So
Buyer refuses to pay.
right. So that would be an enforcement of the judgment. So, but I think we can roll it back a bit. A seller can bring a lawsuit, a claim in court for damages. We can move it through the system pretty quickly within probably 6 to 8 months. I can have a summary judgment motion, which is like a mini trial of sorts. So we can get a resolution with a judge within a year for sure. Where conventionally it would take 4 or 5 years. You hear these long, prolonged trials, hundreds of thousands of dollars, but no, we're able to do these files specifically through summary judgment motions, and we're able to do it quickly, and cost effective, which is very important for a seller. Quickly is the biggest factor, because we can do it within 6 to 8 months. We can have a judgment for you. And then once we have that judgment, then we would have to go after assets. So hopefully the buyer has a property, right? If they do, you're gonna get paid as long as they have equity in that property. If they don't have property, then they might have assets, like they might have a bank account, they might have a job. If they have a job, you can garnish your wages. So there's options available, that you can get debt collectors after them. But it's always a consideration for sure. Before we start any litigation, we make sure that the buyer can pay that debt. Otherwise, you're just be spending good money going after bad. So that's generally the first advice that we would give.
A lot of buyers are losing their homes right now.
Yeah, a lot. So it's a really it's an important decision to make if you're going to try to default.
Yes.
You're most likely going to lose the home that you're currently in if you can't close that deal. So
if you represent a client in a regular real estate transaction, can you represent them in a litigation?
yeah, so as a real estate lawyer, generally the real estate lawyer should not also be the litigation lawyer as well. The reason for that is because the lawyer during the course of the transaction is going to be the point of contact, right? So it's going to be their emails, their letters, their
Witness,
default,
right?
they're the witness, right? So the lawyer cannot be a witness in the litigation. That's one of the number one rules for a litigator. You can't give evidence as a lawyer. So if you're ever in a situation where you're trying to give evidence as a litigator, you have to recuse yourself immediately. So there should be a division between the solicitor and the actual litigator at the end of the day. It is possible, depending on the facts, to do together. I've done it together before, just based on the facts of it was a clear breach. There's nothing in my file that's going to be able to I don't have to give the evidence. The other side already admitted to it, so there's no conflict there. But generally there should be a different litigation lawyer, a different lawyer for the litigation, as opposed to the real estate lawyer. Any lawyer that doesn't have that conversation with you and just goes right into litigation, you probably should find a new lawyer, because they should advise you of the consequences of doing that. So
Thank you, Greg, for having me here, and hope everyone enjoyed the conversation with Greg. If you have any questions about real estate or real estate law, you can contact us both. The email addresses will be on the bottom of the podcast. And thank you, everyone, to listen. Thank you, Greg.
thanks, Kate.